Hello, this is Scott Horton. I will be presenting today's webinar 2023 NLRB update. We have just opened the webinar for attendees to log in, so we will give everyone a few minutes to do so, and then I will get started. As you're logging in, hopefully you can see a cover slide for today's presentation, 2023 NLRB update. We will get started in a few minutes after everyone has had a chance to get logged in and join us. Thanks for joining us. We're just going to wait a couple more minutes until everyone who is registered has the opportunity to get loaded into the room. You should be able to see the cover slide for the presentation, obviously hear my voice, and then there is a chat feature available where you'll be able to ask questions as you may have them during the presentation. Go over all the details in just a moment or two when we get started after everyone has had a reasonable chance to get logged into the system. So we're just going to allow another minute or two to make sure that everyone who is able to join us right now will get logged in. I suspect we'll continue to have some join us as we get started, but we are still just coming up on our scheduled start time, so we give everyone a little bit more of an opportunity to get in if they are trying to do so. Again, if you can hear me and you're already logged in, thanks for joining us today. I'm just allowing a little bit longer to see if anyone else still needs to get into the system before we get started. Okay, to keep us on schedule, I'm going to go ahead and begin the presentation. I think we still have several attendees planning to log in, and hopefully they will do that without any trouble. But I am Scott Horton. I am presenting today's webinar, the 2023 NLRB update. The key theme here being that labor law is shifting dramatically against employers. So I am a partner with the law firm of Gunnar Cook. I also maintain a website through Horton Management Law, which has a blog where I regularly publish legal updates of interest to management and employer organizations. So if you are not already familiar with that website, please check that. I also send out a monthly email newsletter to provide key updates that way as well. In addition to doing these webinars on a nearly monthly basis, whenever there's something new to update, we will do that. Other times we just do sort of best practices or general principles reviews of various topics that may be of interest to you. If you are eligible for HRCI certification, human resource accreditation through that organization, then if you participate in today's webinar, you will receive the code by email. for the pre-approved 1 hour credit. Let's see, you do have access to a chat window where you can type in any questions that you have as we go. I typically wait until the end to do a question and answer segment at that point. But if I happen to see a question along the way that I can fit in the answer to, then I may do that as well. I just encourage you to type in the answer when you get it coming to mind so that you don't forget by the end of the presentation. Just be cautious that there's not any confidentiality or attorney-client privilege in this presentation. So if there's anything specific to your organization that you would have to reveal in asking your question, just consider whether you are comfortable doing that here. Okay, so here's a quick overview of the topics we're going to be discussing. Try to keep this relatively parallel. We'll go off into a couple of tangents as we go, but basically there have been fairly significant recent developments from the National Labor Relations Board regarding work rules and policies and election rules and bargaining rules. With regard to the election rules, in addition to talking about what the legal changes there are going to be or already have been, I am going to give you some statistical information about what has been going on with union elections in the recent times. Before we get any further, I just want to quickly throw up a poll to just get an idea. This will be anonymous, so no concern with identifying yourself here, but just to get a quick idea of whether the companies you work with have unions in them or not. There will definitely be parts of our presentation that apply whether you are unionized or not unionized. So far, everyone seems to be saying that you're from a union organization. No, now we are getting a little bit of no, we're not organized, which again is fine. For various reasons, this presentation may still be relevant to you. So as everyone is getting a chance to respond, it looks like a little more than half are unionized now, at least partially, and then a little less than half are both not unionized and not currently experiencing, as far as you know, a union organizing campaign. So to the extent that those different categories are relevant to different things I'm discussing, I will try to mention them as we go forward. So briefly, in case any of you don't have a full grasp of what the National Labor Relations Board is, it's going to basically encompass the entire presentation today in some way, shape, or form. It is a federal agency that enforces the National Labor Relations Act. The National Labor Relations Act applies to most private sector employers in the United States. There is something else called the Railway Labor Act, which generally covers railroads and airlines, but other private sector employers are usually, with some possible exceptions, covered by the National Labor Relations Act. And we go a little bit more into detail on their jurisdiction in just a moment, but the ultimate policy from the National Labor Relations Board is set by a 5-member board in Washington, D.C. The 5-member board presently only has 4 members. There is a vacancy on the board that has not yet been filled. Not to get too specifically political, but it is unfortunately or fortunately, depending on your perspective, critical to note that there is a very distinct policy separation in this area between the two primary parties, being the Democrats and the Republicans. The Democrats are generally very pro-labor, and the Republicans are generally more pro-business. So right now, the majority of the board, 3 of the 4 current members, are Democrat, pro-labor oriented board members. Hence, some of the changes that we will be talking about today. There are 26 regional offices of the National Labor Relations Board, so they all report back into Washington, D.C., but there are offices scattered throughout the country. I'm located near Buffalo, New York, where there is a regional office. There are 48 total field offices that include the regional offices, plus some additional offices that are part of the regional structure. So, for example, in New York State, the Buffalo region has a field office in Albany. In New York, there are also 2 regions in the New York City area, given the volume of union activity in that area. And then there are other states where there's either maybe 1, possibly 2 regional offices, or some cases where there's not a regional office in a particular state. For example, the Buffalo regional office encompasses some cases in Vermont as well. Anyway, those are the offices that if you deal with the National Labor Relations Board, you're most likely to deal directly with. They're each headed by a regional director, and that term will come up again later. But again, all of these regional offices are driven by the policy set by the board and the general counsel in DC. Overall, these regional offices and the board itself processes unfair labor practice charges and representation petitions. And we're going to talk about both of those categories of cases. Again, the jurisdiction of the National Labor Relations Board under the National Labor Relations Act is limited to private sector employers. So if you work with a public sector entity, a city, a town, a county, etc., then the NLRB does not generally have jurisdiction over your organization. There may be a state entity that has that jurisdiction. In New York, in California, for example, there are the Public Employment Relations Board. A number of other states have similar entities, but many states, particularly in the South, do not have any such entity. And in fact, there's no law that gives public sector employees the right to unionize in a number of those states. The NLRB has discretion not to assert jurisdiction, even over businesses that would technically be covered by the National Labor Relations Act. They use a standard to determine whether the business engages in activity affecting commerce. Most businesses do, but even within that scope, the NLRB does not always exercise jurisdiction. Again, in some states, there are laws and agencies that would fill the gap if there is a private sector entity that the NLRB does not assert jurisdiction over. In New York, ironically, that authority falls again on the Public Employment Relations Board, although in that limited situation, the Public Employment Relations Board would actually be exercising jurisdiction and applying a separate law regarding private sector employers. But it is very rare that you'd be dealing with something other than the NLRB in the private sector. Coverage standards technically vary by industry. The numbers are based on various financial components in most cases, usually an annual revenue number, and depending on the industry, the thresholds range from $50,000 to $1 million. So certainly there are private sector businesses that fall under those jurisdictional thresholds. Many of them are relatively unlikely to have employees, or at least a significant number of employees, and then presumably even less likely to have employees who are looking to unionize. But there are other situations, not just unionization, that arise under the National Labor Relations Act, and we are certainly going to be going right into discussing some of those. Primarily, that arises out of something called Section 7 of the National Labor Relations Act, which gives employees the right to self-organize, to form, join, or assist labor organizations, in other words, to be represented by a union. then to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. It is the language of engaging in other concerted activities for other mutual aid or protection that applies restrictions on employers in dealing with employees, even if they are not unionized, and potentially even when they are not considering or looking to join or form a union. Of course, somewhat forgotten in Section 7 is that Section 7 says that it also provides employees the right to refrain from any and all such activities. To be honest, there's not a whole lot of case law supporting the protection of employees refraining from the exercise of those Section 7 rights. The majority of the cases that get litigated through the National Labor Relations Board and potentially into the courts are going to be disputes against the employer or involving some sort of unionization issues. Before I get into what has changed, in fact, I'm going to remind you of something that has not happened to date. In the last couple of years, there has been legislation proposed in Congress called the PRO Act, which is a multifaceted legislation that would have revised the National Labor Relations Act in many ways to protect workers and unions. Clearly would give employees more rights to unionize, or at least make it easier to unionize, and restrict employers' ability to resist unionization, would impose significant new penalties on employers. At one point, there was some chance when Congress had the White House and the Senate controlled by the Democratic Party that the PRO Act might have passed, but there was not enough support even among the Democrats in the Senate to push it over the line and avoid a filibuster. So that did not happen. Currently, there is no chance it will pass. First of all, at the moment, the House of Representatives is not able to do anything because they're trying to elect a speaker. But even if they did, the Republican majority there would certainly not support the PRO Act. All of that being said, the NLRB for the last couple of years, between its general counsel and the board in Washington, have essentially found as many ways as possible to reinterpret the National Labor Relations Act to do most of the things that the PRO Act otherwise tried to do by statutory amendments. So that launches us into our various discussion topics for today, beginning with work rules and policies. And this is the principal area that is going to be relevant whether you have unions or not, and whether you are at all concerned about the possibility of any of your employees unionizing. So this is actually a very dramatic shift in the standard between what was in place months ago even versus what is now in place going forward. That being said, if you've been around doing this for 10 or 15 years, then you have already experienced these standards going back and forth. I would say about in the last 15 years, the interpretation and scrutiny of employer handbooks and other policies and work rules has really shifted in a pendulum very abruptly, depending on which party is in the White House, and therefore which party has been able to get the majority of the appointments on the National Labor Relations Board. The terms of the National Labor Relations Board members are staggered and fixed for 5 years. So the president can't generally come in immediately and just change all of the members, but over time, as those terms expire, they do obviously shift the balance of power to their party, if you will. One thing you will see in the cases that I'm going to mention today is that most, if not all of them, came out in August of 2023, so just a couple of months ago. And the primary reason that they're all based in August is, even though the NLRB has had a Democratic majority for some time now, one of the positions was expiring at the end of August, so they were in a rush to get any decisions in pending cases issued. So they got those out. That member has now been reappointed and reaffirmed by the Senate anyway, but that is one reason why everything seems to have happened in August, and why I wanted to have this presentation as soon as possible after that. As far as the work rules go, under the previous standards, so again, you can think of this as having been from the Trump era NLRB with a Republican general counsel and majority on the board, the three categories of work rules, or there was an approach that looked at work rules as falling into one of three categories. Those would be generally lawful rules, other rules that required more individualized scrutiny, and finally, unlawful rules. So I just want to give you that basic background, and we're going to break all of these down a little bit. So the old standard, again, first created this generally lawful category, and here are some of the types of rules. So this will make it a little more tangible for you. There has been back and forth case law on civility rules. In other words, rules that generally require employees to be respectful in connection with their job. At one point, there were holdings that employers could not have policies requiring civility and respect among their employees, because in the exercise of Section 7 rights, employees in some cases might have the ability to be disrespectful in advocating for different work conditions. For example, other issues that have been litigated regarding policies include whether or not employees can take pictures or make audio recordings in the workplace. Again, under the most recent previous standard, those were generally considered lawful. I mean, you can imagine a situation where an employer would have a policy that says employees can take pictures all they want as long as they don't have anything to do with seeking better working conditions. I think fairly obviously that policy would be questionable as violating National Labor Relations rights, but general policies here is what we're looking at, and these were before seem to be generally lawful. As you'll see, there's a number of things on here that seem probably relatively typical that employers would expect they would be able to require their employees to do, like not engage in disruptive behavior, to maintain confidentiality, to not defame their employer or supervisors, restrictions on using employer logos and intellectual property, policies against speaking for the company, such as to the media, and then various other policies were listed, including disloyalty, nepotism, and self-enrichment policies. So beyond this, the previous regime in Washington recognized that there were some cases that typically would require more scrutiny. Conflict of interest policies might be more likely to wade in on protected employee rights if they can be read to interfere with, any sort of conflict with the best interest of the employer, because pretty easy to understand that in many cases it may not be perceived to be in the best interest of the employer for the union or for the employees to unionize. Confidentiality confidentiality of employee information becomes more questionable than a general confidentiality policy. For example, employees are generally allowed to discuss with each other what their salary is. But on the other hand, if an employee works in payroll and has special access to that information, perhaps there could be more restrictions on what that person can or can't do with that information. Disparagement or criticism of employer. The previous list had defamation, which is really a legal term. This disparagement or criticism idea is something short of defamation, meaning perhaps the information is actually true, or some other reason why it doesn't create a legal issue under the defamation laws. In other words, if you just flat out say employees can never say anything bad about the company, then that's probably going to raise some concern that you're limiting their rights to seek protection for their wages or other terms and conditions of employment. So I'm not going to go through all of these per se, but there are some other items on here that fell into this category. And then just real quick before I switch to the new standard, there were a couple other categories of specifically unlawful rules. The primary example of an unlawful rule beyond things that just flat out say you can't exercise your Section 7 rights would be a rule saying that employees cannot discuss how much they make or what their compensation is with other employees. For a long time, the National Labor Relations Board has uniformly held that those types of rules are illegal. So the new work standard basically flips the pyramid, if you will, where there was a lot of generally lawful rules, some individual scrutiny rules, and then a couple unlawful rules as of this case that came out recently. The NLRB has basically shifted the presumption. They've eliminated the categorical approach, and basically any employer work rule is presumed to be unlawful if it could chill employee rights. That's not to say that every possible work rule is now actually unlawful. There still has to be some consideration of how it might actually interfere with an employee right. But it is certainly a dramatic enough shift that most employers will want to review their handbooks and policies. It is possible that if all of your policies and handbooks were last prepared and carefully written during the Obama administration, then they may already be relatively in line with what the new standard is, because again, the standard is swinging back and forth. But in most of these areas, it's fair to say, if anything, the current new standard is even more employee or union friendly than what it ever has been in the past. The specific case here is it's called Stericycle. All of these cases are named after the company that was involved. So not really any particular importance that the company is Stericycle, but it just makes it easier to reference. So in the beginning of August, the board issued this decision, which basically says that the employer has the obligation to ensure that no employee would reasonably interpret any rule as preventing them from doing anything that might be protected activity under Section 7. Therefore, the NLRB held that it will interpret any rule in question from the perspective of an employee who is subject to the rule and economically dependent on the employer, and who also contemplates engaging in protected concerted activity. So there's a lot stacked against employers in this standard. First of all, there was emphasis in the decision on this economic dependency of employees on the employer, the idea being that the employee needs this job and can't afford to violate or risk violating any rule, and therefore they wouldn't risk exercising their Section 7 rights if they could possibly think that there was a rule that would get them in trouble for doing it. It also says that the rule has to be interpreted considering at least a hypothetical employee who is actually contemplating engaging in protected concerted activity. Now, to be found unlawful, these rules don't have to actually be implied. Someone can go to the NLRB and just say that here's my employer's handbook and there are these rules, and I think these rules are invalid under, they wouldn't have to say under the Stericycle standard, but ultimately that's what would be questioned, or that's how the question would be answered. And again, this is the standard the board is going to apply, so it doesn't matter whether that particular employee has ever tried to exercise any protected concerted activity rights, nor whether that employee was ever disciplined for exercising or for violating the rule in question. Before we get into the election rules, I just want to highlight the reason, or the primary two reasons why it's risky to have rules that could be interpreted as violating the act. Well, I guess, first of all, certainly if you have an employee that you're going to discipline for violating a written rule or policy, you want to make sure that that rule or policy isn't going to be deemed unlawful, because once you're disciplining an employee, especially if you're terminating their employment, they're going to be that much more motivated to figure out whether they have something they can point to as a violation by the company, and they might end up at the National Labor Relations Board and they could potentially get reinstated or otherwise have their discipline reversed if they were found to have been disciplined based on an unlawful rule. But even where no one is actually disciplined, it is not unusual for unions to get access to employee handbooks and work rules and scrutinize them to determine whether any of the rules might be unlawful, and then file or have an employee file an unfair labor practice charge with the National Labor Relations Board, which not only causes administrative hassle for the employer, but could also result in a finding that the union can then use as part of an organizing campaign to show employees that the company is not treating them properly. Again, without necessarily a whole lot of evidence that there was really anything all that inappropriate going on by having a seemingly innocuous work rule, such as, for example, telling employees that they have to be respectful in connection with their jobs. Okay, moving along, so we have two more topics, the election rules and results. So I'm going to first talk about the changes to the rules and then give you some of the latest data to get an idea what's actually going on out there in the real world. So there are new election rules. So these, again, are rules that have been changed back and forth depending on the administration over, again, say the past 15 years, and ultimately longer than that, but it's become more directly political and flip-flop in that time period. So here we will be reverting to what were previously referred to as the quickie election rules. They take effect the day after Christmas, December 26, 2023. So any election that is sought today or before Christmas will still proceed under the old election rules. Granted, those old election rules are even being applied in a somewhat different manner than they would have been under the previous administration, but they're still generally being followed in most respects. But the new rules will drastically reduce the timelines for the pre-election procedures and tighten the schedules for hearing dates and elections. As I'll walk through, basically the point is to have the elections get completed faster than they previously would. So I'm going to walk through some of the elements, the most tangible elements that have changed. There's a lot of other things behind the scenes, including if you have challenges and hearings and questions to be resolved in the process, how that gets done. Again, I think it's fair to say in all cases, it's designed to streamline the process and get to an election as fast as possible. One thing I don't have on one of these slides is, but the first thing that actually happens to generate an election in almost every case is somebody files a petition with the National Labor Relations Board seeking an election. And so that filing of the petition technically starts the process. From the rules perspective, most of the timelines are based on when the employer receives a notice of hearing. So the petition is filed with the NLRB. The petition generally should be served. Usually it's a union filing the petition and providing a copy to the company. But then to start the formal timelines, the regional office of the National Labor Relations Board that covers the location where the employer is located or otherwise will be handling the case sends out a notice of hearing. Under the old rule, from receiving the notice of hearing, the employer had 5 business days to post a notice of election. So this is a document generated by the NLRB that you have to put up in the workplace saying that, I'm sorry, a notice of hearing. There will be, I'm sorry if I said that backwards. It's 5 days from receiving the notice of hearing that they have to post the notice of election. This is something saying that a petition has been filed and an election will be held by the National Labor Relations Board. At that point in time, you don't know when the election will be held, so that information is not part of this notice. Under the new rule, that has to be done 2 days after receipt of the notice of hearing. So this is an official posting that the employer must make on site to let employees know essentially that this process has begun in case they don't otherwise. The hearing is the next big step. Then under the old rule, there were 14 business days from when the employer received a notice of hearing. Under the new rule, there will only be 8 business days from when an employer receives a notice of hearing. So obviously that starts to speed up the process. The standard for postponing that election and correspondingly the position statement that the employer will have to submit has also changed. Before, the regional directors had discretion to postpone a hearing for a potentially unlimited amount of time. Extensive postponements weren't that common, but a few days here and there was relatively more so. The new rule says that there can only be a postponement for up to 2 business days if a party demonstrates special circumstances, and anything more than 2 business days would require a party to demonstrate extraordinary circumstances. So again, presumably those are going to be higher bars to meet. So what about this position statement? So again, in the typical case where the union or employee files a notice of election, then the employer has to provide a written statement of its position on various issues about the election. They previously had to do that by noon, 8 business days after receiving a notice of hearing. Now that will have to be done by noon the day before the hearing. Since the hearing could be 8 days later, usually the position statement will have to be posted or filed within 7 days. So really, most of this is just showing the trend of speeding up the process. Then previously, there was a responsive position statement, say by the union or an employee filing for an election. that was due 3 days before the pre-election hearing. Now there is no written responsive position statement, and the union or whoever the responding party is, typically would be a union, will give their position on various issues orally at the start of the hearing. So again, given that it's usually the union that's in this position, they both no longer have to put anything in writing and don't have to say anything before literally the start of the hearing where the issues are going to be litigated, and that being despite the fact that they've known since at least noon the previous day what the employer's position on the various issues is. As far as putting things in writing, there were up to 5 business days with possibility of an extension for 10 more business days to file post-hearing briefs, so written documents explaining the party's position and any legal authority that they think supports their position. And the new rule is basically there's no brief. There can be oral argument at the end of the hearing. Briefs would only be permissible with the regional director's special permission, which you can imagine would be in some special case where there's some complex issue and there needs to be something put in writing just so it's clear for some reason. But again, that's going to be the rare scenario. Now, we've talked about this hearing and these briefs. I should just clarify quickly what types of issues are being discussed at this point. So these are things like when the election will be held, where it will be held, who's eligible to vote, which employees would be included in the bargaining unit, which would not for any number of various reasons. Sometimes there could be issues over whether the union is seeking to represent employees just in one department or at one facility or at multiple facilities, and they could be spread out geographically, etc. And there's various other issues, whether there's any legal issues about other unions or previous unions or anything like that that have to be considered. So not every case is going to have one of these hearings. Certainly there are situations where the parties can agree on all of these issues without having a hearing. But and I'd say a decent percentage of the cases, historically, there is some form of hearing to resolve one or more issues. Once the regional director either holds a hearing or doesn't need to hold a hearing or gets briefs or doesn't get briefs, depending, they then issue a decision and direction of election. So usually there's going to be an election, and this is the document that's going to tell you where it's going to be, when it's going to be, who can vote, and those types of things. Under the old rule, they said that the election had to be scheduled at the earliest practicable date, but there specifically had to be at least a 20 business day waiting period between when the regional director issued the decision and direction of election and the election itself. So in essence, even if the hearing resulted in an immediate decision, it would be over 3 weeks before the election could take place. Under the new rule, there is no 20 business day waiting period, and the standard of the election taking place on the earliest date practicable now applies. There is still going to take a little bit of time. There's a couple more things that need to happen in the, behind the scenes status, but bottom line is where you had that 20 business day waiting period from beyond the hearing before, which would probably push the total process from filing the notice of petition or filing the petition to the actual election taking place to something along the magnitude of 1.5 to 2 months. Now, under the new rules, it's quite possible, if not likely, that most elections will in fact take place within about 20 to 21 days from the filing of the election petition. So if nothing else, it potentially cuts the time approximately in half between when the petition is filed and when the election will be held. Here's just a chart that kind of shows the different processes and timelines. If you get down to the hearing, you see that it takes at least 18 days under the current rules to have that hearing. In most cases, under the new rules, it will take only 8 days. So you're already 10 days quicker just through that stage of it. The post-hearing briefs added more time. That will no longer apply. The decision and direction of election doesn't have a time deadline. Obviously, the regional director should try to get that out as fast as they can, but depending on their workload and whatever, that might take, a day, it could take a week, etc. But from that point, we then before would have had an automatic 20-day waiting period, and now there is no automatic waiting period of any length, and the possibility of an election within roughly a week or so from that point is quite possible. So before I give you a little bit of information about the status of elections recently, there is another case, again from August, that I should comment on because it's very important in this whole election representation process situation. This company was involved. It's called CEMEX. Again, that's just at this point, a shorthand way of referring to the case. The decision reversed approximately 50 years of NLRB precedent, where even those rules I just talked about really are going back and forth, and the current rules from the previously Republican majority board had reversed rules from the Obama era board, which were closer to what the new rules are going to look like. But this is a situation where the law is now really being interpreted in a way it hasn't been in over half a century. This kicks in primarily to affect the situation where the union gets employees to sign cards where they will say, I want this union to represent me in bargaining with my employer. If the union has a majority of the employees sign these cards, or a majority of the employees within some potential bargaining unit, they can present those to the employer and ask that the employer voluntarily recognize the union. Historically, the employer was under basically no obligation to give any consideration to that request. Perhaps technically don't even need to accept a copy of the cards and could just ignore the union or whichever individual is trying to hand them over to some official at the company. But now the NLRB is saying that in this situation, the employer has two options. One option is to voluntarily recognize the union as the bargaining representative of the employees in the bargaining unit that the union is seeking to represent, which is not an option that the overwhelming majority of companies would ever consider. The other option is to promptly file a petition for an election with the National Labor Relations Board. Promptly is specifically defined by the board in this CEMEX case to mean within 2 weeks. So you get the cards and they appear to be majority support of the employees. You now have less than 2 weeks to decide whether you're either going to voluntarily recognize the union or file a petition with the National Labor Relations Board to start the whole election process. So again, most of what we were talking about before with all the procedures for the election kind of assumed that in the majority of cases, the union is going to be the one filing the petition and the employer is going to be responding. Now there is a greater likelihood that the union is going to follow this path and put the burden on the employer to seek the election. There are slightly different rules for the timing of when the employer files for an election, but rest assured that, again, they're clearly designed to have the elections occur pretty quickly So again, the employer can buy close to 2 weeks of time before they file for the election, but then after that, they could be seeing election in 2 to 3 weeks. The other part of the CMEX case decision that's changing standards is a ruling that any violation of the National Labor Relations Act leading up to an election may result in a bargaining order without an election taking place, or if the election has taken place, regardless of the outcome of the employees' votes. In other words, it's not unusual for either party to claim that during the election process or the lead up to the election that the union or the employer respectively did things it shouldn't do, impermissibly trying to sway the employee voters. Now this is saying that if the employer engages in any type of unfair labor practice, rather than rerunning the election, they will just issue a bargaining order saying that the employer now has to recognize the union. There are factors that should be considered, including the number and severity of the unfair labor practice charges, the proximity to the timing of the election, the size of the bargaining unit, and the margin of the vote, and the number of employees that the misconduct may have reached. I mean, the reality is they wouldn't have issued this standard if they weren't trying to make it more likely to find that the employer did something that gives the labor board the authority to issue a bargaining unit independent of the outcome of the election. So we'll have to see how the cases go on these various factors, but expect many cases to result in a bargaining order. Okay, so here's the data. Union election petitions, these are called RC petitions. You'll understand why I'm giving you this maybe seemingly random shorthand acronym for these. This RC petitions are petitions where the union is saying we would like to represent the employees and we want them to hold an election. The union has to have at least 30% support through cards or petition that they can show to the National Labor Relations Board to get one of these elections. So this is just raw data on how many of these petitions are filed in a year. These are based on the NLRB's fiscal year, which begins in October and ends in September. So this 2023 fiscal year just ended, a few weeks ago now. So in 2023, there were a total of a little over 2,000 total RC petitions filed, 2,112 to be more exact. Last year, there were a total of 2,072. In the previous fiscal years, the numbers were down almost certainly somewhat due to COVID. You figure that the 2019 fiscal year ended in September of 2019. COVID really hit then during the 2020 fiscal year, causing a downtick that continued into 2021. One thing we've seen is the raw numbers are relatively inflated because of the number of Starbucks locations that have petitioned for individual elections. These are in the hundreds. So last year, for example, in 2022, this chart shows at the top, the darker blue is the number of Starbucks elections. Obviously, even without the Starbucks election, 2022 was back up to and a little above the 2019 level. Obviously, most of the Starbucks stores that filed these petitions and had elections in 2022 wouldn't be eligible to have another election yet in 2023. So we've seen fewer, but still a relatively significant number of Starbucks elections in the last year. I believe it was about 140 Starbucks in 2023 had elections, And in the previous year, there were closer to 350 Starbucks. But obviously, even ignoring the Starbucks, there is an upward trend. By comparison, quickly, these decertification or RD petitions are situations where there is a union in place and an employee or multiple employees have filed for an election to try to get the union voted out. It is only really worth noting here that, this kind of confirms that filings generally were down in 2021. Otherwise, there hasn't been that much of a dramatic change in the decertification petitions over the last several years. It's a relatively static situation. But what is very interesting is that the CMEX decision came out at the end of August, and we had 1 month left in the 2023 fiscal year after that happened, where that standard was in place. And we immediately saw a dramatic increase in the petitions filed by employers called RM petitions. And these, in essence, are what the employer now would have to file if they're not going to voluntarily recognize after being presented with cards or a petition from employees. You will notice here that in September alone, there were as many RM petitions filed as there usually is in an entire fiscal year. So it was obviously something that employers have taken seriously, and they do not want to voluntarily recognize in these cases. So they're moving for elections. Will be interesting to see how this trend plays out. I can tell you, I already looked at the numbers to date in October, and it looks like we're heading right back towards that same number, 30 or so RM petitions filed in October as in September. So this is a new reality. We'll see how that affects the petitions filed by the union, whether those continue to go up or they go down somewhat because they're now putting the burden on the employer to formally seek an election. Before this new ruling, most of these dark blue RM petitions would have really been situations where there was probably already a union or multiple unions, and the employer believed that maybe the union had lost support of the members. So they're really historically more akin to these decertification petitions that are filed by employees than they were to the RC petitions. So it's going to be a little bit harder to interpret what these cases are all about going forward, because some of them still will be cases where the employer is trying to get the union out. But obviously, there's plenty of reason to believe, even without the specifics, that most of these light blue September cases are response to the unions seeking representation. And the final little statistical information here, and we'll move on to our last subtopic, is how many of these elections are unions winning. Probably none of those RM cases filed in September have gotten to an election yet, or very, very few. So we couldn't get much meaningful data from that subset. But this goes back to just those RC cases where the union has sought the election to represent the employees in the first instance. Generally, there is obviously a somewhat upward trend in the union success rate, keeping in mind that this is before the new so-called quickie election rules are taking place, which are certainly designed to increase the likelihood that the union will win the election. I think historically, these numbers are closer to 70% over time, and 2023's rate of close to 78% is pretty high. It is possible that would still come down, because this is looking at the total number, or the win rate from the total number of elections that were decided based on election petitions that were filed in that year. So there's a number of petitions that were filed in 2023 that haven't yet gotten to an election. So some of those will still be decided, and then change this percentage, exactly what that's going to mean, whether they're going to be more likely to result in union wins or not. Who knows? But so this isn't actually going to be the final 2023 win rate, whereas the older years are more likely to be final or pretty close to final. Is going back a year or two, you're very unlikely to have more than a couple election petitions that were filed that haven't yet been decided. Okay, now just to finish up with something that more directly applies only once you do have a union in place, this pertains to bargaining rules and standards. There are two new cases, again from August, that signify a notable shift in the National Labor Relations Board stance on employers' rights to make unilateral decisions concerning work conditions during contract negotiations. And this could be generally either before a first contract is negotiated. In other words, you have a new union and you haven't agreed to your initial collective bargaining agreement yet, or the union's been in place and your contract has expired, so you need to negotiate a new one. The old standard for relevant purposes comes from a case involving the Raytheon company that allowed employers to make some discretionary changes to work conditions even during negotiations if they were similar in kind and degree to past practices. For example, if the company regularly reviewed which insurance plans to offer each year, for example, and basically offered the same thing, but just made, minor adjustments based on whatever the insurance company was offering or something like that, that might be similar in kind and degree. Some bonus decisions, again, if you normally gave a $10 to $50 Christmas bonus and you continued to do that, or if you normally gave a $1,000 to $5,000 year-end bonus to employees and you continue to do that with roughly the same financial impact to employees, that might have been okay under Raytheon. Now, in this case involving the Wint Corporation, the board has said unilateral changes by the employer only permitted if they're consistent with both a long-standing practice and one that is not informed by a large measure of discretion or involve a large measure of discretion and emerged post-union certification. I think I repeated some of those words in there, but basically the longstanding practice and informed by a large measure of discretion prongs are designed to make it very difficult for an employer to be able to show that they have the right to make a unilateral change pending negotiations. The case specifically says a longstanding past practice must occur with regularity and frequency such that employees reasonably expect them to continue. If you literally gave every employee a $500 bonus at the end of every year, then that might qualify. But if you were in that scenario of somewhere between $1,000 and $5,000 and we get to decide how much any individual gets, then there's much more risk that that would involve too much discretion for the board to permit it. Just one little further extension on that from this TechnoCap case said that specifically rights that employers had under a management rights clause in a contract that has now expired, the employer no longer retains those rights pending negotiation of a new contract. So in essence, the management rights clause expires with the contract. So just because you normally had the discretion to do something and it had been agreed to by the union, once the contract expires, that right now expires as well. There's long been case law over which rights expire with contract expiration and which don't. Obviously, you can assume that currently, generally, in most cases, the board is saying that whatever is better for the union is the right interpretation. So I will answer any questions that you have in just a moment. I know we are pretty much at the end of our time. This is my last point to make before we wrap up, and this is really to summarize and let you know a little bit about what we expect to see coming forward. Based on that CMEX case that just came out less than 2 months ago now, or about 2 months ago, there will certainly be more card check presentations, more requests for voluntary recognition. Exactly how much that's going to shift in that direction versus unions just filing the election petition themselves remains to be seen. There will always be cases where the employees want to just surprise the company with the election petition rather than giving them the heads up and potentially 2 weeks to file on their own. But that will be something new that will be a game changer in at least some cases. We will see more and more unfair labor practice charges. So overall, in fiscal year 2023, the NLRB had a 10% increase over the previous year in unfair labor practice charges. That was a further increase over the increase from 2021 to 2022, which was a 19% increase. So we are up something like, 25-30% over just a couple of years now in total charges. I mean, you can file unfair labor practice charges against the unions, but it's certainly fair to assume that the majority of that increase is based on charges against employers. What can you do depending on your situation? Almost all private sector employers should be reviewing and potentially revising their handbooks and policies as a result of the steer cycle case. It is quite possible that you have policies that the labor board would find unlawful if they had reason to scrutinize it. If you have any fear of a union organizing campaign, you might have more reason to be doing that. Because again, the unions will try to use that against the company. If you are currently involved in a union organizing campaign, or if you have an election pending, then you definitely want to talk to a labor lawyer before you start changing your policies, because that could constitute a unilateral change and potentially lead to an unfair labor practice charge in and of itself. But as long as you don't have anything pending against you, you should be doing that. Most companies that had any concern of unionization should see the changes in the election rules and some of these other cases as even more reason to be increasingly proactive in trying to prevent unionization, because you're going to have less time once you find out that the union is ready to be recognized. There will be individual challenges for different industries. Higher education, the private colleges and universities are going to continue to see potentially dramatic shifts, increasing organization among faculty members if there isn't already that, but also among students, which could include graduate students who have teaching assistant positions. There have been a number of cases of even residence assistants, students who have some role in a dorm or residence hall, unionizing, and the athlete unionization question is probably coming to college or university near you sooner rather than later. There are some professional industries that normally hadn't had much union activity that may be seeing more of that based on some initial instances. So by and large, there is some sort of wave going on here. There is some sort of agenda. If you don't want to be unionized, at least think through all of this material to figure out whether there's anything else you should be doing now. With that being said, I will take any questions. Again, if there are any confidentiality issues that you can't disclose enough details here, then there's my contact information. You can reach out to me and I will see what I can do to help you. Otherwise, so far, I haven't seen any questions come in. Hopefully, everyone's just been digesting this information and taking notes. I will have the slides available for you right now, but you will also get an email that will have those link to those as well. So if you want to click there, you can download the slides for the materials. I don't see any questions still. If you have a question or anticipating having a question, then go ahead and type that in. I will just wait a little bit longer to see if there are any questions. Otherwise, hopefully this has been informative and I look forward to seeing all of you at the next webinar. Okay, well, I'm not seeing any questions, so hopefully I answered everything. Or, oh, yep, the recording will also be available. Good question. So yeah, the link, you'll get an email probably tomorrow, as long as you are registered for the webinar, that will have both the slides and the recording of this webinar. Yep, thanks for reminding me to mention that. Okay, well, I'm not seeing any more questions. So with that, I'm going to go ahead and wrap up. And thank you again for joining me today and look forward to seeing you at future presentations.